So the case that the Supreme Court heard today was a case about a Los Angeles fashion brand that is seeking a trademark. The issue for the brand is that their trademark, the word they want to trademark, is a four-letter word, and it is spelled FUCT. That's the clothing brand, and they've been in business since 1991, making T-shirts and hats. And what they'd like to do is be able to use federal trademark law to get protection so that they can go after counterfeiters and protect their brand. The issue is that the federal government is refusing to trademark the brand, and that's because federal law has a provision that says brands that are scandalous or immoral should be refused. And in this case, the brand has been described as scandalous and immoral because of that name. The brand itself says that this is an unconstitutional restriction on free speech and that that portion of federal law should be struck down. The justices did a number of verbal gymnastics in the courtroom to avoid saying the name. So, for example, Chief Justice John Roberts described the brand as a vulgar word at the heart of the case. Justice Samuel Alito called it the word your clients want to use, and Justice Stephen Breyer called it simply the word at issue. The government's argument in this case is not that they say they are not restricting speech. What the government says is that they are simply declining to promote certain speech by refusing a trademark. So the company can use their brand's name, they just don't get trademark protection for it. And so they're able to print shirts and hats and all kinds of items with their brand's name, but they don't get trademark protection for it. It would seem that the brand at the center of this case would have a strong case before the justices, and that's simply because 2 years ago, the justices invalidated a similar provision of federal law that said disparaging brands could not be trademarked. So in that case, it was a band, an Asian American rock band, that wanted to use the name, wanted to trademark the name The Slants, which was seen as disparaging, but they were declined. And the justices said that that was not appropriate, and they struck down that portion of federal law that limited the trademarking of disparaging brands. So it would seem that this case would be similar to that, but we'll have to wait until the Supreme Court's decision expected by June to know what they do with this case.